Hello and welcome to today's webinar. My name is Grace Oserole and I am one of the co-directors of David Wyld & Co Solicitors. Thank you for joining today's webinar, in which we'll be talking about specifically the Overseas Business Representative Visa. We often shorten this to the Sole Representative Visa. So before we go into the presentation, I'd like to talk a little bit about the firm of David Wyld & Co Solicitors. So the firm was founded by Mr. David Wyld in 2002. It is a regulated practice, so we're regulated by the SRA, which is very important because it means that for our clients, we don't need to go through any other brokerage or any other agents in order to be able to deliver services. And I joined the practice in 2014. We're a two-partner firm, and we have extensive experience in immigration law, and that essentially is my focus. My practice focuses on business immigration, entrepreneur applications, and high net worth individuals. I myself have 27 years of experience in UK immigration law, having qualified in '99, and I'm the senior partner of the firm. I'm also the supervisor and the head of the immigration department. Here you have a quick snapshot of the immigration team. So as you can see, I sit here, and then we have solicitors, we have OIC level immigration advisors, we also have a coordinator, and we have two assistants to assist us with the execution of all the applications that we handle. So today's agenda. As I said, we're going to do an overview of the Overseas Business Representative Visa. We're going to talk about what is the Sole Representative Visa, the key eligibility requirements. We're then going to talk about some of the key changes that were made in June 2020, just after the lockdown. And then we're going to very specifically look at the genuineness test. And I'd like to look at that through the lens of the Home Office, so we can really see what they look for in applications when they're considering whether to approve or not an application. So, what is the Sole Representative Visa? Well, this is a category of visa for overseas businesses that want to establish a branch or subsidiary of their business in the UK. And it allows one senior employee of the overseas business to come to the UK to set up, run and represent the company here in the UK. We move on to what are the eligibility requirements, very important. And I tend to put this into two categories. And the first category is the documents that the representative themselves has to provide as evidence for the application. And secondly, the company documents that the business has to produce. Let's look firstly at the representative visa requirements. Well, the representative has to be an existing employee of the business, and we show that through their contract, payslips, and bank statements, where we can clearly see that the salary has been paid to them directly. They must have been recruited outside of the UK, and we typically look for job advertisements, a letter of employment, a contract as well, to indicate that that person has actually been recruited overseas. Key factor is that they must not be a majority shareholder or have any ownership or control of the overseas business. And typically we will look at share certificates to establish that. They must have the relevant industry experience and the knowledge to set up and run the business in the UK. So we're essentially looking at a senior employee of the business, and typically we're going to look at the CV, and we're really going to try to bring the CV up to a certain level where it's very clear that this person is the appropriate person to run the branch here in the UK. The business is giving the representative full authority to take operational decisions on its behalf. And, this is a full-time position. So, the employee is not entitled to do any other work. This is their focus whilst they're here in the UK. Key element is that the partner or the spouse of the employee, the representative, themselves must not be a majority shareholder or have any control in the business. And we'll talk about that a little bit more in the later slides, because that's a key change that was made in June 2020. There is an English language requirement. It is the lower level. It's level A1, and that's the European framework of reference qualification that's required. And again, if we need an applicant to sit a test, normally it's not really a major part of the application, but we need to show the Home Office that that standard of English has been obtained. As I said, the representative must not work for themselves or any other, or do any other employment in the UK or represent any other business. And then the last one, which is something which we look at the beginning, but also at the end, is that in order for the representative to qualify for settlement, if that is in fact an objective of theirs, they mustn't spend more than 180 days outside of the UK in any 12-month period. We refer to that as the residential requirements. Let's look at the business now and what the business eligibility factors are. So they must not have any existing branch or subsidiary in the UK. And that includes an employee or a representative. So effectively, this is a new venture for the overseas business whilst they are looking to establish the branch here. Another key element is that the business must be trading or intend to trade in the same business as the parent company. They must also be required and intend to maintain the headquarters and the principal place of business outside the UK. And of course, the representative has to be paid the appropriate level of salary for a senior employee. And these are all factors that the Home Office are going to be looking for in the paperwork. Does it all gel together? Does this look like a genuine venture to establish a branch in the UK? And a key factor as well is that the company is required to give full disclosure in terms of all the company documents, and that includes the affidavits that have to be signed off, that includes management and company accounts, and that also includes bank statements. So there's quite an onerous requirement for the business to show that it is genuine and that this intention to come to the UK is real. Okay, let's move on to the key changes that were made in June 2020. Now, of course, a lot of people may have been looking at this visa prior to lockdown at the beginning of in March 2020, and so you may have looked at the provisions and thought, well, look, it looks like I'm eligible. But whilst we were in lockdown and whilst the pandemic was ongoing, the UK government made some tweaks, I would call them, but also one key change to the rules, which anybody looking now to looking seriously at this visa as a consideration, they need to really ensure that they still qualify. And the first thing is that whereas we've spoken about the representative not being a majority shareholder or having any control in the business, there is now a requirement that the partner or the spouse, so essentially the dependent of the main applicant, that person themselves must not be a majority shareholder or exercise any control in the business. Now, the Home Office obviously look at certain things to determine ownership. And of course, they'll be looking at share certifications, they'll be looking at the terms of partnership agreement, or any other arrangement that the business has in place which establishes the foundation of that business and how the ownership is divided and shared up between the key parties in the company. Now, what's the effect of this? Well, the effect of this is that the new provision effectively prevents some of the smaller businesses to apply. Why? Because in a smaller business, typically you'll have maybe husband and wife running the business, maybe the children are also in the business, and they will have the ownership within in the hands of a very few people. So you can see there that you'd really have to check whether there is too much ownership in one or the other business owner, which could potentially prevent them being able to qualify for this visa. Now, it is possible to get around this by selling shares, if this is a real consideration. And of course, if that's done, and there's absolutely nothing wrong with that, the Home Office will be looking for, sell share certification, and they go back 12 months, but in some cases they will go back 24 months just to see how things have shaped up. Whilst, as I've said, there is a requirement for the representative and their spouse not to be a majority shareholder, presently the rules don't prevent a representative and their spouse or partner cumulatively having a majority shareholding. So we look at this and we say, okay, well, that means that certainly even smaller businesses could qualify, but we really have to look at that carefully. And it's potentially an area where the Home Office may decide to make some changes in the future. But as of now, as I said, there's nothing preventing the representative and their spouse having jointly having a majority shareholder ownership. Okay, let's move on a little. And whilst I am talking, please do put your questions in the chat room. I will be taking questions at the end of this webinar. So yes, please do jot your questions down, and we'll certainly try and get to as many of those questions as possible. Okay, I want to talk about genuineness, because this is an element that the Home Office have introduced. It's a theme that was really introduced with the Tier 1 entrepreneur visa, but June 2020 they decided that they wanted to introduce an element of genuineness into the sole representative visa. So what is genuineness? Well, let's take a look at some of the key factors that the Home Office will look at. They'll certainly look at how long the proposed representative has been an employee of the business. So, for example, someone who's been with the business for a month is not as convincing as someone who's been with the business for 6 months, but that doesn't mean that they're not an employee of the business. We'll look at the experience of the representative. Do they actually have the qualifications to do the job? And of course, the CV is the key document that the Home Office will be inspecting. Interviewing is not a mandatory requirement for the sole representative visa, but it's a factor to consider. If I sat a senior employee down and asked them some questions of the business, how would they perform? So you're essentially looking at it in that light. Would this person be able to answer questions, general questions and more specific questions about the business? What is the proposed salary for the position? Well, the sole representative visa doesn't make any stipulation on how much a rep should be paid, but clearly where it's a senior employee of the business, someone who's been with the business for some time, someone who's essentially going to be working autonomously to a certain extent here in the UK, the salary has to reflect that. Something else that they're looking for is how many other employees does the business have in the home territory? So does it make sense that they would ask just the one employee to come and set up the branch here, or is there a hub of employment or activity in the home territory, which means that it actually makes sense that someone is coming over here to the UK to establish the branch? Another thing that they look for is, does the success of the business focus on just one or two key people? If it's looking like this is a small company where activities centered around just one or two key people, then the Home Office may question whether this is viable, whether this is genuine. Now, this is an interesting one, because the question that the Home Office asks is, does the proposed expansion mean that the centre of operations can be maintained in the home territory? Now, again, a larger business has resources to maintain itself in the home territory and in the UK. A smaller business may not. So even if you have a situation where it's a genuine business, but it means that the key people will be here in the UK, well, clearly there's a failure to meet this requirement in terms of maintaining the centre of operation in the home territory. You cannot have a situation where, you know, the key directors are here working in the UK. The Home Office will look at that, and that application could potentially fall for refusal. And again, this is an obvious one, but is it clear from the business plan that the business will be trading in the same business as the parent company? You may be surprised, but you do have business plans where there's some elements of branching out. I would certainly advise my clients that for the purposes of this application, we focus on the core business, and you know, any expansion plans can be thought about at a later date. But certainly for this visa, we have to do this. We have to be operating in the same activity. And also another thing that the Home Office look at is whether or not the expansion plan is viable. Do the financials back up the proposed expansion? I mean, that's quite an obvious one to me. I can, you know, I'm not an expert with business plans, but I would look at a business plan and I can see fairly quickly whether or not, you know, this looks to a complete stranger, whether this, you know, looks viable as a business opportunity. Another thing is, how researched is the business plan? You know, the business plan, interestingly, the business plan is not stated as a mandatory document for this visa. However, I think it's virtually impossible to do this application without, you know, preparing a well-researched business plan. And if that is done, it essentially covers off a lot of the points in terms of eligibility for the business. So you can kind of, you know, use one document to cover off a lot of elements and essentially state to the Home Office that you qualify for this visa. The Home Office will also look at the turnover and the profit of the business, and that goes back to the matter of the viability. Is expansion to the UK something which is a logical development that the business is, the next step the business is looking to take? So what we've done there is we've covered off some key elements of the sole representative visa. We've spoken about the eligibility from the point of view of the representative and the documents that the representative has to submit. We've spoken about the documents and, we've spoken about the documents that the business has to provide to show that, you know, this is a genuine venture into the UK. We've looked at some of those key changes that the Home Office has made, and they are tweaks, but actually in practice, if you don't focus on those things, you know, you may find that you go a certain way with an application and find out that, you know, we don't qualify. So for me, and in terms of our practice, what we do is we will always take our prospective applicants through a checklist, prerequisite checklist, to ensure that before we start even looking at documents, that they qualify for the visa. And so those are essentially the main tenets of this visa. So why is David Wyld the right choice for your business? Well, the team has a combined experience of over 55 years in UK immigration law. So we therefore have the strength, depth and knowledge to successfully deliver this application. And, you know, if this application, it means that you don't qualify, we can look at other options for your business. With the experience comes, I would say, complete understanding of the sensibilities, the vulnerabilities and the challenges that our clients face. So we're able to assess and to navigate to solutions very quickly for our clients. We can tell you very quickly whether or not you're going to qualify. We can say to you, well, if you don't, here is another option for you, and you know, seek to find a solution that actually works for you and your business. We understand the importance of client management. Clarity is absolutely important. Regular updates is a key thing that recurs, you know, when we speak to our clients. They want to be updated regularly. They want to know and be confident that their advisor has the knowledge and the insight to, you know, take them through an application through to success. Here we have a range of other applications that the firm also deals with, so they're just listed in alphabetical order, but, you know, we do, of course, we cover the full spectrum of immigration applications, from visitors visas, sponsor licenses, entrepreneur applications, etc., etc. So just ask, essentially. We have the contact information for the firm. I'd just like to thank everybody for joining us for the webinar. Please do continue to type through your questions. We're going to try and answer as many of your questions as possible, because obviously that is a key part of you coming on onto today's webinar. So please do that, and we'll try and get to as many as possible, as I've said. Thank you.